Some South Dakota lawmakers are looking to change the way initiated measures and constitutional amendments are placed on the ballot. After what have been lengthy legal proceedings around the constitutionality of Amendment A, legislators are looking to avoid confusion in the future.
However, opponents argue that in doing so, citizens' voices could be stifled. Austin Goss joins us from Pierre and tells us more about some of these efforts. Good evening, Austin.
Good evening, Kelsey and Sam. With the constitutionality of Amendment A in question, legislators are looking to tweak the amendment process. While some argue it will prevent future confusion, others say it will stymie a process that works just fine. There are bills on the South Dakota state legislators' docket that would alter the way initiated measures and constitutional amendments are brought about, having to do with everything from the percentage of voters needed to pass something to the font size used when writing a measure. Representative Mortensen is bringing SB 86, which would require the Secretary of State's office to review the constitutionality of ballot measures before they are placed on the ballot.
This is now the third cycle in a row where we've finished up an election, and within a couple of months, one of the things that passed on the ballot was getting challenged in court. And so a few of us got together and said, this isn't healthy. This does not inspire a lot of confidence in this ballot measure system, and how can we fix it?
Critics say that such bills are knee-jerk, and that the current process to get something on the ballot works just fine.
People like the initiated measure process. They like the ability to have a say in those things. And so I think the bills we're seeing this session is just an effort by politicians to try and insert themselves into that process.
The Secretary of State's office points out that as it currently stands, it isn't exactly easy to get an IM or a constitutional amendment on the ballot. For this last election, to get an amendment on the ballot required almost 34,000 signatures. That's over 5% of the state's registered voters. An initiated measure, about half of that.
It's a thorough process. I mean, you got LRC weighing in. We verify all the signatures. The Attorney General writes up an explanation. You know, people can read up on the ballot questions.
No one is really considering the question of, is this a proper way under our Constitution to amend the Constitution? We didn't have anyone looking at that on the front end. We didn't have the ability for anyone to challenge that it was single subject or not beforehand. And so now we wind up in the mess that we're in with Amendment A.
Now, bills dealing with those processes are at various points in the legislative process. You can read more about legislation specific to initiated measures or constitutional amendments on your Dakota News Now app. In Pierre, Austin Goss, Dakota News Now.
Austin, thank you.